Yes.
Hey, there we
Yes.
are.
Yes, we are live. And my new mic that works great for video does not work as great for this, unfortunately. So
two old guys trying to use technology.
I blame JR. It's JR's responsibility. Here it is, not legal advice, which is with JR Brian, and not legal advice. That's my legal name. I changed it, by the way, just to let you know.
Little Richard.
Little Richard. That's right.
Richard.
Little Ricky. I was called Ricky as a little kid.
People are calling me Mini JR right now, and I got to tell you, I'm not quite sure why.
I don't know.
I think it's because of you.
No, I have nothing to do with it.
It's bad enough I feel like I'm Tiny JR, but Little JR, Mini JR.
That might be a compliment, though. Did you know, by the way, that the guy who invented knock knock jokes should get a Nobel Prize?
Oh my God!
Oh my God! Wow!
So stupid.
Woo. Before we start, that was really bad. I appreciate that. That was from Tiny JR. By the way, thank you for that joke contribution. Before we kind of start into it, we were talking about this a couple minutes ago. The fires in Hawaii. You know, I know people from all around the country end up going to Maui. I've been there before. I've been to the area that's hardest hit. And I also live in Southern California, so I'm familiar with fires. I've been evacuated twice in my current location. I'm not bragging, but it's very disorienting and very surprising. And listen, my hearts go out for those people. You know, all the people that lost their lives, and it's really, really bad. Hopefully they will be able to get through it as best as possible.
Well, I think they said there was, and I recall during the week reading this, that there was like 32 people had been killed. But, you know, we were talking before that banyan tree that's in Lahaina Town.
Lahaina Town. I like the way you say that. Lahaina, not Lahaina. Not Lahaina, but Lahaina. I like that.
That's how they pronounce it. That's how that's how they pronounce it.
That's how you pronounce it. That's not how. Yeah. Most people who speak English say it's Lahaina.
Lahaina. All right. And let's just point out that once again, I've found out the topics 2 minutes before we started the live stream. So,
untrue. Absolutely untrue. I'd say about 7 minutes.
7 minutes.
7 minutes. So anyway, the best to all those people, and hopefully, you know, they get support of everybody and they can rebuild. And it's a great place to go on a trip. Anyway, so we're going to talk about a bunch of crap as we usually do. Last week, unfortunately, JR split on me. I don't know what happened, bail revocation or something. He didn't really specify, so I really don't know to this day. I was all set to go forward, and all of a sudden, like 30 seconds before we're supposed to go on, I get a call from a bail bondsman, whatever. It was
from a bail bondsman.
It was really unexpected. Really.
You gotta stop saying that shit. People are gonna take that shit seriously.
I'm not being serious.
I was on vacation. I did not feel like joining Richard on Sunday night. Actually, I sat on the deck. I chatted with some good friends, and I, you know, drank wine and watched the ocean all night. Much better than being on a live stream.
Yeah. Allegedly, but we'll move on anyway. So we're going to start off with a little MMTLP talk. We were talking about that. Obviously, there was a reply date requested by 15 congressmen on the MMTLP situation. I don't know. Maybe you know. Was there ever a acknowledgement by Gensler that he was going to reply by a specific date?
No, there was no acknowledgement. And, you know, I was anticipating one of two outcomes: that number one, he wasn't going to reply, or that the reply was going to be very brief and basically say that there's an open investigation. So, you know, as we were talking beforehand, We don't know that he didn't reply. I don't think we've got any confirmation from any of the congressional offices that folks have been talking to or working with. So, so yeah, we just don't know at this point. But that's, I mean, no one should be surprised by that.
Yeah, I mean, I thought, and who knows, because we'll see what happens. But I thought the most likely conclusion was if he was going to reply, they would ask for some more time. That would be their request. And we don't know as of this point in time. And I kind of want to briefly go what goes on. So at this point in time, there's no subpoena. So there's technically there's no order binding them to do diddly squat at this point in time.
No, I mean, that's it. Look, the letter is great. The fact that 15 Financial Services Committee members signed it and sent it off to him is amazing. But at the end of the day, that's step one in any process to an investigation. You and I both know that. Step one is a simple, this is what we want, please turn it over. And either the agency or the individual or the organization complies or they don't. And so if they don't, then the committee needs to figure out, well, what's the next step? I mean, that's standard operating procedure for any congressional committee.
Yeah, and I could give you like the what happens in a civil case, because that's all I could. Although I've done a few criminal cases, not personally done them, but have been involved in them. But I've been in a lot of civil cases, and so this discovery usually doesn't go, you ask, they give. That is not the process. The process is you would expect that both sides are trying not to give in to the other side. So both sides are, when they are the responsive party, they are trying to respond as narrowly as possible and until they are pressed to respond. Now there are exceptions to that, of course, but typically, and it's not unusual, you send out a request for a production of documents, you get a request for an extension. The reason why you have to grant a request, a reasonable request, if somebody asks you for a 3-year extension, you don't have to give that. But if they ask for 30 days or something along those lines, you kind of have to, because if you try to enforce that in a court, the judge would be pissed at you for not having at least gone through the exercise of seeing if you could have worked it out. So after the time, and I'm giving you the typical route of how things go in a civil case. Could be different in before the congressional committee. Could be better. Could be worse. Could be the same. So I get a request for a time extension. I grant it. Then they respond. The response is never complete and never to the point where I could say, now I know everything and I could move on. It's typically, I go through it, takes me a little while to go through it. I compare my requests to what they provide and I see what the deficiencies are. And there's usually deficiencies. And if they're significant enough, and they usually are because that's why they're not there, then you have another round of communications, letters, etc. And then maybe you have an agreement. If not, then you have you file a motion in court, and then you hopefully convince a judge to grant it, and then hopefully the other side responds as the judge requested, which isn't a sure thing. So it's never a shock to me when you're dealing with issues of discovery requests, and that's how I see, in effect, the request to Gensler was like a discovery request. Historically speaking, I think he's kind of, excuse my language, but I think the SEC are kind of like dicks when it comes to responding. They're not, and I'm not talking about MMTLP. Just in general, they're not super timely and not super responsive. So maybe this issue will get them to go faster, but it's reasonable to expect that it will take a little time.
Right. Yeah, and going back to what you said earlier, I mean, the whole process of discovery and any type of investigation like this is a process, and it's a lengthy process. I mean, I can tell you when I was at the airline and we were in litigation cases, we get interrogatories that were 10 pages, and they're laser focused questions, and then you send them back, then you get another set of 10-page interrogatories based on those answers. So it's not hey, we're in discovery, here it is, or hey, we're in an investigation, we want all this stuff and you're going to give it to us. It's just not the way it works. Plus, as you know, the other side always has the opportunity to object to specific types of information that is requested to be turned over. And so then now you've got that little mini investigation or mini hearing going on about that one part or that one piece of the evidence. So it's a process.
And whereas, if you don't do it for a living, you think that the trials and those kind of things are really the main things. It's really these kind of hearings that are these are what a case is really about. Because since most cases are going to resolve anyway, no matter what the differences are, because that's just the facts. The little battles when somebody gets something or doesn't get something over time, that does add up, and that does impact people's decision making and settlement position. And I'm sorry you missed the joke; it was a great one. So it does impact you. So it shouldn't faze anybody if it takes more time. I'm sure at some point in time, if Congress thinks this is important enough, they will go back and make a further request if in fact there hasn't been a response. And again, as JR indicated, we don't know if there hasn't been a response. We just presume we don't know. At least nobody I know, knows. Maybe somebody else does. Perhaps they responded in full. Perhaps. But we don't know that.
Not telling the joke again. Enough. We're not going down the jokes again.
No, we're not that. It was too good. I got to save it for another time. But anyway, nobody should feel like depressed that they didn't respond timely or didn't respond in the time frame that was requested. Now on the flip side, I was talking to JR about this because one of my theories here, like we have a lot of stupid theories, and I'll throw out another stupid theory, is that how long Gensler stays in office impacts his, or at least my belief in him changing positions. So for example, if he was going to only be in, or if he only intends to stay in as SEC chairman for another 6 to 12 months, then what does he care about, like all this stuff? All he cares about, getting through it and being on to the next mission back at either, I'm guessing, a guy like Gary Gensler is going one of two places. He's either going to a place like a Goldman Sachs or a place like a top 10 law firm, one or the other. Yeah, he's going to cash in on his experience.
Right, and he'll be a rainmaker. He'll work on clients. He'll be more like a trophy CEO or trophy executive that they red carpet out to some other organization or client that they want on board. I mean, it's no different than what Bernanke did. All those guys.
It's worth it. And it's worth it to them, to the firm, to have somebody, for prestige of the firm, but also, as JR said, they bring in a lot of dough because clients want to do business with them. Because they're going to be connected. They're going to be connected. They're going to have certain connections that are going to bring them a lot of business.
Right. And when the economy goes to shit and the market tanks, Gensler will write a book about all the great things that he did to fix things, and he'll go on his book tour and command $50,000 for a 2-hour speech or whatever. So,
unless you're like completely motivated by public service, and obviously there are people that are motivated by that. And those people, I understand why they, do what they do. Some guy like Gensler, I don't get it. I don't really understand why somebody who could make a lot of money. This is before he became the SEC commissioner. He could have made a lot of money in a much more comfortable setting without the scrutiny. So why does somebody want to take that position? I don't know. But the premise was, if it was short time, I don't think we would have any kind of influence over him. But if it was longer and if he wanted to stay, then we might be able to, because otherwise he's going to have to face the wrath all this old period of time. And his term started in 2021, goes for 5 years. So he goes through 2026, June of 2026. So he's around. So if he wants to stay in, he's at our beck and call at this point in time. In other words, we have influence over him because he wants to stay in that position.
Right.
And he's going to be in there.
Right. And the other thing too is remember, the Republicans right now loathe him. I mean, look at we've talked about this in the past, Warren Davidson's legislation, basically getting rid of him. We know that there are specific Republicans that are targeting him. So on some level, if he wants to continue in the position he's at, he's got to appease them. So that tells me that he's going to at some point reply. Whether he replies after the Wells notice has been responded to, or if he replies beforehand or whatever. But if he wants to remain in office, he's going to have to reply.
Yeah, and Don, you're correct. It could be the next president could can him, but if he wants to stay in the position, he still has to pretend like he's going to be there through 2026. And I would expect him to be, more receptive than he would be otherwise. Mm-hmm. And he's getting a lot of crap. Listen, there's no question he's getting crap. So now that we know he's there through 2026, we could just like everything else, just up the pressure. Make it worse, make it harder on him. Call him out for not, if in fact they don't respond timely, call him out publicly for not responding timely, ignoring Congress. Call him out. I mean, there's no reason not to. He's already super rich, but that doesn't stop somebody from wanting more money. Honestly.
No, it never does.
Listen, if he's making, I'm making up numbers, but let's say he'll make $20 million a year. Even if he's worth, let's say, and I'm making up more numbers. If the guy's worth $300 million and he's still making 20 million, you think, why does the guy really didn't make 20 million? Every guy who's making 20 million wants to make 20 million. Just kind of the nature of the beast, just how it goes. So we don't understand, but the guy, most of those guys want to continue. They don't want to give up. He's got a position of power. I'm sure he wants to use it to his future advantage. And we will see. But at this point in time, we really can up the heat on him. I really believe at this point.
Yeah.
Okay. So we talked a little about MMTLP, and we're obviously waiting on the response. And I think there were some other Congress people and some other senators that may have joined in the crowd in going after or requesting a response. Like I think Warnock from Georgia, he joined in, and I know there was a couple of Congress people that did also.
Right.
So the number, and again, I think it should be an election issue. So if we keep on raising the numbers, we can make it into an election issue, really.
Well, that people are making it an election issue because look at, they pulled Don Huron into the conversation a few weeks ago, and he's a guy that's running for Senate against Rick Scott.
Right.
And he's not even gone through his primary yet. So, there's definitely outreach to that level of politics.
Yeah, and by the way, I will address MMTLP and my nonsensical, farcical battle against all the villains from the Washington D.C. area. I'll get that in order. But along with the MMTLP thing, we talked about that new research paper that came out from the Congressional something talking about naked shorting. You saw that, right?
Yeah. Well, I sent it to you.
Yeah, you did. So you must have seen it then. Maybe you didn't see it. Who knows?
It was a research paper from a bipartisan group. I don't know if it was a committee or something like that, but the best way I can explain it is when I was at the Pennsylvania General Assembly, I was on the bipartisan policy committee, which was made up of a Republican, a Democrat, an executive director of a Republican and Democrat, and then there were specific members of each party that were assigned to that committee. And then your political persuasion in the research group, which I was part of, mattered not. So you worked on solely bipartisan issues. And I believe this white paper came from a committee that's similar to that. So there are a group of delegates from both parties in the House that are probably part of this group, and they produce information like this for the entire chamber.
Yeah, and so I'm going to take it to MMTLP. Oh, this wasn't. I'll reference it again later on. So the exemption, there's an exemption within naked shorting, or at least in the paper, and it's referenced kind of it is an exemption for a bona fide market maker doing bona fide market making activities.
Right.
So there's a requirement. So somebody, Joe's brokerage and hedge fund, can claim they are a market maker. That does not make them a market maker. And doing illegal activities does not make them a bona fide market maker engaging in bona fide market making activities.
Right.
So I know it's used as a defense because it's there, but it doesn't always apply. And just because some market maker, and I'm just going to make up two, GTS and Canaccord like that off the top of my head, just because some guys claim to be market maker. Yeah, just out of my pocket here. So just because some guys claim to be market makers and doing legitimate activities does not make it so. So, and I see it referenced by the plants opposition, Mr. Angel, whoever, and they omit that key fact. So just because, and you can take over.
Well, no, I was just going to say, like we were talking right before we jumped on, what is bona fide market making? It's to provide liquidity to the market, and can be liquidity as in the options chain, either calls or puts or actual shares, but it's to do nothing more than to provide liquidity. Bona fide market making is not selling shares that you got on, a toxic loan and just spitting them out. Bona fide market making is not saying we're going to sell 300,000 shares today. We don't have locates. We don't have borrows. Get rid of them. That's not bona fide market making. The problem with the bona fide market making is twofold. Number one, it's really the Madoff exception. And as we know, Madoff was a piece of shit. And the fact that we still have rules and laws named after criminals in this country is absolutely disgusting. But the other part of it is no one's keeping their eyes on the chickens in the hen house, and it's letting the foxes roam free. So this whole notion of a market maker needs to provide liquidity, but they need to be a bona fide market maker. It's form over substance, because no one is paying attention and regulating these guys. These guys should be hauled in every month to say, look, we want the data. We want to see what you've been selling out into the market and why. Why did you have to sell 300,000 shares of ABC company at 9:35, when the market opened on Wednesday, August 13th? No one's doing that, and they should be. And that's where our regulators are failing.
Yeah, and I don't think, and let's go to MMTLP because it's a common topic. I think people have an interest in MMTLP. Nobody can say that, and I'm just making up numbers, but let's say there was 165 million shares that were supposed to be in AST from NextBridge. Let's just say for the sake of discussion. And somehow there was 820 million shares. Nobody is going to be able to justify that was proper market making activity. Maybe, exactly. Like there was maybe some you could say, but when you're like 5 times the amount of legitimate shares, it's going to be a tough one to justify. And I certainly in my arbitration, I am certainly going to make that argument.
Well, read back over the Dole decision that the judge wrote back in 2017. There's no mention in that opinion that the market makers made more shares than they needed to. That was not even part of the decision. It was, hey, there's a real problem in clearing and settlement. And as we know, that wasn't the issue either. They naked shorted the shit out of it. The judge in Sorrento, and I'll give you a good segue into Sorrento. The judge in Sorrento never said, well, how come these market makers were selling these shares when they didn't need to be? Look, people know the issue now. And the issue is these organizations, these market makers are naked short. Well, these illegitimate market makers are naked shorting these companies. And Sorrento's just the perfect example of that.
But it's interesting to me that research, and I'll get to Sorrento, and thank you. It's interesting to me, though, that the research paper kind of touched on the issue of naked shorting and that exemption, like somebody had spoken to somebody to get it in there.
Oh, sure.
Because it's confusing, for somebody who doesn't understand really what's going on, it sounds like it could be a legitimate activity, what's occurred. And that's why they throw it out there as an element of a defense, really. But,
well, part of what the community should do is start educating their congressman on saying, well, look, that's the legal term for it, but the name that it's truly called is the Madoff exemption. And once you realize why it's called that and why he pushed so hard for it, you can see why it's a farce. He knew exactly what he was doing when he pushed Congress for that exemption. He knew it was to do nothing but enrich himself.
Right.
I wonder at that point if he knew how bad he was in the hole that he tried to get that exemption put in place to help him sell shares that he didn't have to get himself out of the hole. But at that point, he was already lost billions. So
I'm sure that was, I don't know for certain, but I'm sure it's MMTLP at least inspired that research paper, I think. And whoever amongst the group that again whoever's there still, and I know there's a bunch of people, whoever's walking the halls of DC, because it ain't me. I appreciate your efforts, and you obviously have made an impact, and we all appreciate that. At least I do, and I'm sure JR does also. But it's out there, and I expect it'll kind of come back, and people will still address that exemption as the excuse. And I think and that's kind of why we're talking about it. I think there's enough facts relating to just the disproportionate and imbalance in shares that shows it really couldn't have been legitimate activities, and therefore it doesn't apply. And but again, I expect to see it on Twitter, on Spaces, other places, because that's why it was put out probably in the first place.
Right.
Now you mentioned Sorrento, and that was I have to go through it each time. Sorrento was a bankruptcy case. It was a bio company that did cancer drugs. Ended up in a financial issue. Was naked shorted. Filed Chapter 11. During the Chapter 11, the bankruptcy judge found there was naked shorting. So the parties got together, and it appears now all parties, including the brokers, got together, and the debtor, the company itself, and a committee filed a motion to be able to let the naked shorts, who were confidential, they weren't defendants in a case, remain confidential if they elected to cover. And there was an offering that was done, and if there wasn't enough in the offering, then they could buy directly from the company. And the price was going to be calculated based upon a somewhat company favorite rate. And what happened was the court approved that resolution so the shorts could cover. I tried to, there's like about a bunch of, there's a lot of law firms involved. Eventually I was able to get a hold of the attorney that was the lead attorney in the adversarial action. He wasn't able to tell me everything, and he said he would tell me everything the beginning of the year. But he did acknowledge that they did let the shorts cover, and that is being worked out. So the shorts will cover. It's more complicated because notwithstanding whatever confidentiality agreements are, but it's within a bankruptcy, and there is an actual restructuring going on within the bankruptcy. So there may have been, I don't know if there was a toxic loan or something else, but they're refinancing. So the deal with the naked shorts is going along with the restructuring. He can't talk until the restructuring is done, but he did acknowledge they did work it out with the shorts, and the court did approve it, and they did dismiss the brokers also. They dismissed everybody, but without prejudice, which means that if these lying sons of bitches turn out not to have disclosed what they had actually done. So there was a point in time in this case where the judge said, how many shares do you have of company Skylex? And Morgan Stanley, I'm making up a number, says 4 million. well, if it turns out there's 9 million, then this release doesn't apply, and they won't be out. So that's why it was without prejudice.
Well, I will tell you, when you told me that before we started, again, 2 minutes before we started, I was surprised that they reached out to you. I thought they'd blow you off. So the fact that they got back to you is really cool. That's interesting that they're covering. So, and as you and I both know, I'm curious, did he say if all of them if all the broker dealers joined? They all did.
Yeah.
Wow. Yeah. Wow. So that tells me they really wanted to get rid of that liability. They knew their asses were grass.
Yeah, they did. They got caught. They got caught.
Those brokers joined. Isn't that something?
It is. And again, our pitch was because we think that might be a eventual some kind of remedy that a company might be able to use to get the shorts to cover.
Any micro cap or small cap company that goes into bankruptcy needs to be using that Sorrento case as an outline.
Yeah, if I were like Mullen.
If they don't, their bankruptcy attorneys are incompetent. Seriously.
Yeah, I mean, for me, like, and I don't know, I'm a small shareholder, small enough. I don't really care what happens. I wish I had as much fun as you do. My problem is I only see out of my left eye. This is the problem. I only see out of my left eye, and my comments are on the right side. So if I turn to the right, then I'm like this, and you think I'm a moron, and I'm looking like this. So Mullen Automotive.
I got a lot going on here right now.
I could see that. Mullen Automotive has had a troubling history. It's a company that says it's been naked shorted, and it's a company that might file at some point in time Chapter 11. This is like, here you go. This is the setup. There may be other avenues, and also we don't know. And listen, I'm going to certainly bring up Sorrento in my arbitration. Why not? Why not bring it in any federal case? Why not bring it up to at least assert that the courts have the authority to make the naked shorts establish the share count? That's at least appears what's happening.
Yeah.
Happy 60. By the way, happy 65th birthday.
Who's 65?
Ordinary angler.
No, we talked about this when we first kind of started watching Sorrento back in April. And
can you cuss?
Obviously, you and I weren't doing YouTubes, but we started talking about this and kind of look at where it's at now. The judge ordered the share count. It took a month. Then all of a sudden we had a couple of motions filed. Then we had this offer to close these things out. And it's amazing. That blows my mind that all those brokers signed up. I would have thought some of them would have rolled the dice and said, no, we're going to go to litigation. But they were caught.
Yeah, I'll know more, because the guy was very nice. He was very, he said as much as he could say. I'm sure I'll know late, in 2024, the details. And I think, by the way, and I'm really disgusted that we have people, I think honestly, it's bullshit that people are calling for more cussing, in my opinion.
Oh, I didn't see that. Yeah. Is that what it is? More cussing?
Yeah. I'm really offended.
I'm actually very well behaved on this channel. When it comes to my language.
You do. But anyway, Sorrento, and maybe somebody will cite it in a federal case and its federal judge will use it, maybe. But anyway, that was a difference. So the council has spoken. We now have confirmed the covering, which is great. I mean, I think that's great that they did work it out. He also said he wasn't specific. He said the price they got, the share price, was a reasonable share price, more favorable to the company side than otherwise. Yeah, because they had leverage.
But let's take a step back, and that's great for the company. That's great that they worked it out. But the shareholders were still the ones that got screwed, right?
Yeah, true.
The shareholders are the ones that lost value based on the naked short selling. So how do those people get made whole? And that's always been the thing with all of this. It's great that these organizations can go into the courts and get things taken care of, but how are the shareholders? And let's use Sorrento as a perfect example, because Celiax, whatever the dividend was, had a high of like $13, $14 a share. What about all those people that bought in at $13, $14 and it was naked shorted down to $3?
You're right.
How are those people made whole? And that's always been the issue with some of these pieces of, or some of these organizations going into litigation. Is the company going to turn around and give some of that money back from the sale of those stocks that goes back to the shareholders? Probably not.
We mentioned it at one point in time, you know, difference between like a class action and derivative action. You know, a class action where the shareholders can benefit by getting a portion of the damage award, and the attorneys get a percentage of the damage award. Usually the amounts that are given relative to the claims are less. I mean, just to be honest, they're usually significantly less. The law firms, it's a lot of work, by the way, because it takes about two years usually to get a class certified. So that means like where you're now at a position where you can move forward. So you burn, and I'm not like asking for sympathy for these big law firms, but they burn a bunch of money for a couple of years, and then if it goes, they make a bunch of money.
Right.
But the individual consumers usually don't do great. There may be exceptions, but usually they're not doing great, especially if it's a big class, you know, big class of people. So I know this is interesting. I was going to talk about something, and it's going to lead into that. So I was going to talk about a little bit about Robinhood. So, you know, Robinhood.
I hadn't been paying attention to that. So that's all. Yeah. I knew something was happening. I saw it on CNBC, but that was the extent of it.
Yeah, and obviously, well, I know. Obviously, I was aware of Robinhood. I was aware of the IPO. I tried to buy it because I thought it would go up, not because I was going to retain it, but I thought it was a very, you know, it was a big deal when it came out as an IPO. Usually those are overpriced, and eventually they kind of work their way to their destination. Then I heard about the GME and all that other stuff, and there were a bunch of them. I guess 13, we'll call them the meme stocks, but that's doing the service because it doesn't make a difference. Because in my mind, you could have, you know, pile of shit stock, and if it makes you money, then so be it. But in this case, the meme craze was going on. People were making a lot of money, and Robinhood probably was in jeopardy or in an awkward position. They elected basically to get rid of the buy button and maybe other restrictions, because it was kind of the way it's couched is restrictions. And there was a class action was filed thereafter. A judge dismissed the case, threw it out because in the contract, and I did a video on this, in the Robinhood contract, there's a provision buried, and it might be in other brokerage contracts too, but it's more important to Robinhood for a very obvious reason. But in the contract, it basically says, if we decide to not let you trade for any reason, we could do it. And it's literally that blatant and one-sided. And so everybody who had a Robinhood contract in their customer agreement had that provision. So when Robinhood elected not to let people trade fairly and make money, they were doing it per the contract. And in the state where the action was brought, I think it was Florida, there wasn't like a state law that might have provided a separate remedy. So you could have said it's not the contract, but there's a separate duty that they owe.
Well, that's why they formed a contract in Florida.
Right. So the judge found against the class. They appealed last week. The appellate court 3-0 in Atlanta on the 11th Circuit found again in favor against the plaintiffs, and so the only remedy that remains is going up to the U.S. Supreme Court, and that's discretionary. This case doesn't do it for me. I don't think they would take it. Yeah, I don't think it was taken.
Wait, was it a 3-judge panel? They can still go the full. They can. Full
it was 3-0. It was 3-0 though.
Yeah.
3-0.
They won't take it.
Probably not. They probably won't. Anyway, so it was an interesting conclusion. We'll have to see how that goes, whether they go. But the interesting part was the contract provision. And Robinhood did it. They took advantage of that provision. So anybody, and I don't have an account at Robinhood, and I'm not telling anybody what to do. But if you know somebody's going to do that because they did it in the past, you're basically, if they do it to you again, that's on you. So
now they even
if it were me,
yeah, I'm just saying,
yeah, if it were me, I would move to another brokerage. And it may be the case, every brokerage might bury something like that in. Then I would check to see if they actually use that provision. And you can find out. Right. But what's interesting about this, so this is the backdrop, and we kind of talk about this in the big picture. So class action, they got banged twice. In 2022, some truck driver, 27-year-old truck driver, filed an arbitration claim against Robinhood, a FINRA arbitration claim for the same ground, same reason. He won. He got his damages, he got interest, and Robinhood had to pay all the costs.
How do you know that?
The result. How do you know I kind of found it. I was doing some research, so I found it. Batista versus Robinhood. Wow. Yeah,
that's interesting. Yeah. Send me that. I'd like to read over it.
So I found it interesting because that's FINRA arbitration panel, but they found differently because they found an obligation. They found a duty that Robinhood had a duty, and that's different than what the courts did. So, we always take the position that the arbitrations suck and whatever, and they may suck, but here's a case where, interesting, you got a better remedy by going to arbitration. Now, maybe, so I thought it was interesting. So maybe Robinhood will face a bunch of those cases now. And obviously the decisions can be cited. I've cited it now. Batista versus Robinhood. It could be cited, and I would encourage, listen, I'm not telling anybody what to do, but if you're in Robinhood and you got screwed and your statute of limitations hasn't run out, then why wouldn't you take a shot? Especially if you can find a lawyer to do it on a contingency. So they take a percentage, so you don't, no cost to you. So you have no risk and no downside. Right. Hey, I think it's something to consider as an alternative. I'm not saying it's a main thing because it's really difficult for most people to do, and it's hard to find attorneys to do it. Understand that. But if you're in a position where you can do it, here's an occasion where maybe it's available.
Right. Well, we've talked about, in terms of MMTLP, we've talked about arbitration and the pros and cons. And, and you and I have always been, you're in arbitration for a specific reason. I've always been of the mindset that no litigation, and again, I'm not suggesting, proposing anything. I'm just telling you my own personal thoughts. Until the final share count is revealed, until the final share count is discovered, until Congress gets a hold of the final share count and makes it public, litigation is going to be a difficult hill to climb. So is arbitration. And you and I've talked about that personally. Yep. The share count is the be all end all. It just really is. It was the be all end all in Dole, and they didn't even realize it until, they were in another class action lawsuit. So the share count in MMTLP is really the holy grail. Once that comes out, then there's really sky's the limit. It really is. At that point.
Yeah. And I agree. And I don't know where this takes us. So I agree. It's tough to prevail in the MMTLC TLP situation. It takes a lot of effort, and I don't know how it's going to come about. I'm doing it because, again, my client is very understanding. He's a really nice guy, and his dogs love him.
You know what I say about that, Richard, right? An attorney that represents himself as a full client.
That's right. But a very nice client too. A very nice client. But, notwithstanding that I want to prevail, I also have opportunities, I believe, where I might have access to information that I may not be able to ordinarily get. And when the movie comes out, you'll be able to understand more. You'll understand more.
Chapter 10, Richard's Secrets.
Yeah. But that information will be, hopefully be valuable to the community. So as a result, and kind of like along those lines, I promised. Unfortunately, I promised I'd send a letter to AST and make a request. I did.
Oh yeah, what they say? Did they get back to you?
I know they got it because I got a confirmation they got it.
Did you send it certified, right?
I
Good
did.
job.
I know lawyer would. I know they didn't respond because I didn't get anything back. And I know I worked on the complaint because I said I was going to file a complaint. So I'm going to do that. So I'll file a complaint tomorrow. Some point in time tomorrow, I'm going to sue AST in California. I'm whatever. We'll see where it goes.
You know I'm not laughing at you. I'm just laughing.
I think you are. Big secret sauce. I like that.
Why? What is that? Oh, it's why I should have known.
Yeah. So I'm going to pursue AST. Like I said, I don't know. I expect pushback. I don't know why they wouldn't just give us the information. Honestly, I'm not asking for anything other than the current share count of MMTLP and or NextBridge shares. That's all I'm asking. That's all. I don't want any identifying information. No names.
How much time did you? Yeah, how much?
I gave them a week. A week.
Okay.
A week is enough time to get a response back saying we need more time.
Got it.
Yeah. So if they didn't respond, and by the way, I expected them not to respond, but I figured it's worthwhile when I go in front of the judge, because this is how it's going to go. I'm going to play it out. I don't know how it's going to play out, but I'm going to play it out, and I'm going to tell them again. I'm going to tell you how I'm going to play it out. Filing a complaint. I'll prepare some type of injunction proceeding where I'm going to ask the court to order them to disclose the current share count. We'll be in front of a judge. Judge may say you're full of it. Judge may say great, but there'll be an action and there'll be a judge. They'll get to rule on it. And if they deny it, we can appeal that ruling also. But I'm going to do that because I said I was going to do that. And if we can get, I believe, if we can establish that the share count at AST is substantially more than what it should be, that would be probably a positive thing for us in the community. So I'm hoping to go that route. But I expect AST to object and oppose it all the way around. But it will be filed Monday. And they are aware of it. They know it's coming. And we'll see where it goes. The other part, because I got to say this part too. So the other part of the arbitration is, as I mentioned, they answered, I'm preparing a response that will be filed this week. I'm not obligated to put this response in, but because I thought that counsel for Fidelity acted like complete scumbags in their answer, I elected to address that nicely. And basically, and I'll after it's out, I'll kind of go through it quickly. But basically, I'm going to saying, if you want to go this way, then these are the kind of things I could say. I'm not going to say them, but these are the kind of things I could say. And I'll explain and put it in proper order. And part of it concerns the congressional response along those lines. And at the same time, and again, this is this coming week, and at the same time as a response will go in, at the same time, there will be the discovery request. And I have received some like 90-page list of potential arbitrators for our arbitration. I have to go through them and I have to vet everybody.
How many pages? 90?
It's like 90 pages because they give a full resume.
Well, yeah. Oh, okay. Got it.
And they say what cases they've been on. That like there might be like 100 cases the guy's done. So theoretically, and it's like, probably like 100 people. So theoretically, it could take me like 6 months to vet everybody. Obviously, I'm not going to do that. I saw one guy that interested me was a cop, like an like a captain.
Well, remember there was that push. They did a push a year ago to get non-institutionalized people to be FINRA arbitrators.
I would think, I don't know.
Regular people.
How would you think? I would think law enforcement would be sympathetic to our position. What do you think?
I think anyone that's not in the industry would be sympathetic to any position like this. I mean, I'll give you a perfect example. When I was at the airline, we were in front of mediators and arbitrators all the time, and the ones that did not have, I mean, they all had union experience, but we found that the ones that didn't work in the airline industry were always the ones that were more fair than the ones that did work in the airline industry, because the people that work in the airline industry, they're in that box. It's like anything, you see things the way you've known them your entire career. Whereas if when we had people that weren't from within the airline industry, they wouldn't look at it in terms of the airline. It would be reviewed in terms of fairness. So that's what I would expect for any FINRA arbitrator that's not in the financial services industry. You would probably get a more objective person, whether that's a lawyer, a judge, a cop, a stay-at-home mom. It doesn't matter. You'd have more objective eyes in terms of fairness. Whereas people within the industry, I mean, let's face it, if you're in the industry, you're at a financial institution or you're at a trading desk. So you're going to see it through the eyes of how you saw it from that position that you were in.
Yeah, I was always amazed. I've done not like hundreds of jury trials, but enough. And I was always pleasantly surprised how fairly jurors reviewed cases. These are civil cases. And I didn't always believe that. And I had lawyers on juries before, which I thought was a fun thing to do. But I was pretty pleasantly surprised. So sometimes when you broaden out the base, kind of what you're saying, when you broaden out the base, you get a fairer consideration. And people are, especially collectively, people are pretty smart. Really, I'm again pretty amazed, because I don't always have that opinion. But in that context, I'm really pleasantly surprised that they collectively they do it. So anyway, I'm in the point where I'm choosing arbitrators. Maybe I will come forward. I'll throw out some names, and I can have the community participate in the selection of arbitrators. I'll pick my list of 8. We can have a vote. We'll see what happens. What the contest? Why not?
Hey, listen, point, dude.
It's as good as anything. Exactly. Ultimately, I'm going to pick these people. I have like a hunch, but is it better than a hunch? Maybe we can even demonstrate it. We'll go for it. We'll pick it randomly like that. Well, I let the community pick it randomly, and if we win, we can say this shows you what a crock this is. That it makes no difference, even like picking arbiters in terms of how it goes out. I wanted to address briefly Alpine GTII. That, or maybe you don't know. So it's
I checked out. I was not on Twitter at all. I actually wasn't on Reddit. I literally sat and watched the beach.
Yeah.
So whatever happened this past week, I've got very little background.
They briefed the injunction, the Court of Appeal. So Alpine is the FINRA is going after Alpines, trying to expel them. They're in proceedings. Alpine went and got an injunction. They went to the Court of Appeal. They lost. They went up. They got an injunction. Now FINRA wants to go in front of the entire court to have a hearing, which I don't think is going to happen, by the way. Now the 3-judge panel who granted the injunction extended the briefing date on the appeal for a couple of weeks, but the final briefing is going to be like the end of November. So I would be surprised. I don't think because what happened is FINRA wants the full court to step in to get rid of the injunction.
Right.
But because there's an appeal ongoing, and because the case is going to be briefed, unless that court jumps in right away, I would expect them let it be briefed and oral argument, etc. And you know, kind of the sequence it would go. At least I'm speaking for California. Sequence would go. And again, I'm not a appellate lawyer, but I've done appeals. I've done pretty much, you know, a little bit of everything. I've done appeals. So after the final briefs are in, then the court considers the briefs. It might take 60 days, can be like 90 to set oral argument. And then they would set it again, probably like 60 days out if they wanted oral argument. And that's kind of how it would go. So that's kind of like your timeline. But again, notwithstanding that, it doesn't stop FINRA from going into federal court and enforcing the violations. And you didn't know about this part because I did a video about this while you were gone. And I'm sure you didn't spend your beach time looking at this video. Prior to that order in April of 2022, were basically...
I did read that. I read over that only because I saw someone post something about pedophiles. And I was like, what the hell is that about?
Yeah. So this is the amazing story. So Alpine,
piece of shit.
I know. So, you know, we believe that Alpine, they're kind of scumbags. That's our position. And we're not the only ones. And it's basically, that was based in part on their business practices. I didn't know, and I don't think if you knew this before, but prior to April of 2022, I'm going to take you a different route. Prior to April of 2022, that's when the order, a cease and desist order, was put into place because Alpine was found to be ripping off people, amongst other things.
Right.
From 1984 through that period, they had been disciplined. Now, when I say disciplined, that doesn't mean like you did 6 things wrong one time. That means this is 40 different occasions they were disciplined by the SEC and FINRA for lack of supervision, improper accounting, misappropriation of money, 40 separate times. And FINRA did nothing up to April of 2022 to impede that progress. And I was astonished because after that, we get a cease and desist order, and then we get 35,000 violations. But now the coup de grace is in 2015, and I got this from a application that Alpine submitted. They wanted to get somebody approved as a representative of their company. And they got a final decision in October of 2022. No. In 2015, they hired some guy who was like a law clerk to deal with the regulators and to respond to regulator inquiries, issues about short sales, any impropriety that we claim happened. This guy would be the guy who'd be in charge of responding to the regulators and to the consumers. And this happened in 2015. And unfortunately, in 2016, and this is according to the FINRA documents, that's what I'm basing it on. In 2016, and I don't know what happened prior to 2016, because this is usually not a first time, you know, my knowledge. I was a psych major in college. I hear professionals talk. Apparently, he tried to molest an underage 16-year-old girl.
Yeah.
A girl was under 16 in a movie theater while her father was sitting next to her.
While her father's sitting next to her. Just think about that.
Yeah. And it was like multiple attempts. So 1, and then she moved over. 2, she moved over. 3, she screamed. Father got alerted, went outside, called the cops. He got arrested. Admitted to it.
Admitted and pled guilty. Pled guilty. And they tried to make an argument that he wasn't statutorily disqualified, that he didn't really plead. They basically were trying to turn it on a legal dime. Isn't that disgusting?
Yeah. So there's a provision in. They were asking for him to be the representative of the company. Yeah. And dealing with the regulators and the issues that we're talking about.
Yeah.
And this is not, so this is not like somebody who didn't know. I'm talking about management of Alpine. This is not somebody who didn't know. 2016, this has come out. He pleads guilty. It was the only twist on it is they were able to get the court to basically, there's a concept called deferred entry of judgment, where they basically say, we're not going to enter the judgment. You're on probation for 6 years. If you don't do anything, okay, we'll let it go. We won't enter the judgment. If you are, then tough. So
it's no different than what they do to teenagers. That's what they do to teenagers when teenagers are caught underage drinking or with drug paraphernalia. If it's a first offense, it's a very similar process. But this is not a teenager. This is a man that put his hand on a 16-year-old girl's leg in a movie theater, not once, not twice, but 3 times while sitting next to her father.
Yeah. So that to me means somebody who has again, I don't know. That's not correct. If it was my daughter, I'd be pissed. Sounds like it's compulsive behavior. And I'm no expert, but my expectation is it's difficult for people with that compulsion to be perfect.
Well, you know what it tells me is if the people in that internal organization are okay with that individual working for them, knowing what he has done, do you think for 1 second that they aren't committing other crimes? Do you think for 1 second that there aren't people in there? I mean, if you're willing to look at that particular situation, I forget what the guy's name was, but he was going to be the individual in the organization dealing with the regulators at Alpine.
It was something like
they're going to make an argument that he's capable and he's an upstanding citizen and he should represent this organization. Can you imagine the things that's going on inside of that organization? If you've got people that on the board saying, sure, we want him. He's great. He's a good upstanding citizen. We want him to represent our organization.
Yeah. His last name, I think, is Iverson, not the basketball player. Quite honestly, I'd heard from Ham how big of scumbags all those people were. What I think the Kramers he refers to there. And I thought it was just because of their business practices, because I don't think he even knew about that at the time, kind of when I was just kind of looking for stuff.
Well, I don't think anybody's mentioned that until it came out last week.
No. I mean, to me, that means you're willing to do basically you're willing to hire anybody, no matter what their history is, to deal with your issues. Because again, this is dealing with the regulators. This is dealing with this is exactly what we're talking about. They're basically saying we're going to hire the biggest scumbags on earth to deal on our behalf. This is our agent. We're proud of having him as our representative.
It's like hiring Al Capone to be your tax analyst.
Yeah.
Or Jeffrey Dahmer to be your cook.
Yeah, be your cook or your taster. Your taster, maybe. Yeah.
Put him in the executive gourmet section.
Yeah, but I was appalled when I saw that. Yes. Really, I was appalled that they, that really affixed to me that they were really scumbags. And I don't know, because we don't know what other companies in that similar situation. So there's a lot of other hedge funds who are shorting, and they could be at risk, right? We talk about Finger Motion, and there, AMC. There's a bunch of other companies that are, where Mullen, where there's companies at risk. We don't know what lengths those companies might go, what unethical acts they're engaging in. But anyway, this one with Alpine just was because they didn't.
When you stoop to that level, that you're willing to hire a convicted. I mean, I don't even know if you can use the term pedophile, call this guy a pedophile, but when you're willing to hire someone that's been charged with sexual assault of a minor and put them in a position of power in your organization and say that they're a good representation of your organization, there's some serious problems with that organization. You've got some leaders in that organization that are deficient in their thought process, because that's crazy to me.
Not only that, if you look at the picture you ever seen the picture of the Kramer family?
Yeah.
He's got a daughter. I mean, don't you have any I mean, doesn't it impress you in any respect? And anyway, I found that I don't think he is. I don't think he's a registered sex offender. I think he got the state.
Yeah. Well, he's not, he didn't have to register because the verdict got deferred. So he didn't have to do any of those things.
Yeah. My point is more like, my point is more,
make no mistake.
Yeah. My point is more that, usually people don't get caught the first time they do something. So especially when it's compulsive behavior, I presume this guy is not like the first time he did something like this. It was just the first time he did it. He just couldn't control himself in a position where maybe he didn't even see the father. Maybe he didn't even notice the father, maybe, and he didn't think he was going to be at risk.
Well,
but it was more.
He was 16 years old in a movie theater.
No, less than 16.
Was she less than 16?
Yes, under 16. Yeah. Yeah. I mean, again, it's more, in front of the father. It's just really, besides being disgusting, it just tells you about the owners of the company.
Right.
Who, this is okay. This is all right. Anyway, I was really astonished by that. By the way, Robinhood and that contract provision, I forgot to mention, what it made me think of? It's like if you go to Las Vegas and you lose $250,000 playing blackjack and you sit down and they say, no, can't play anymore.
Yeah.
That's it. Out you go. Yeah. You can't win your money back.
If you go to the larger scheme of things, if you look at, and this was big, they talked a lot about this when GME, spiked to $500 and some a share, and how, it was all payment for order flow and the gamification of stock trading. But, where things are at today with all of these hedge funds being caught. I mean, if you look at Citadel's balance sheet, it's 69 billion sold, but not yet purchased. If you look at the bigger picture of things and you look at the ROBINHOODs and the Weebles and the Fidelities and all of these, gamification apps, it's really their own demise, because people, the retail community, a large percentage of the retail community now realizes that what's going on in the market, and people are now buying and holding these stocks. And that's what's getting them in trouble. And it's because it's so easy to take the money out of your bank account, put it in Robinhood, buy 500 shares. And that's going to be the demise, is really the gamification of all of this and the ease at which people could trade. And it's because of payment for order flow. There's all kinds of stuff talked about how, payment for order flow is the worst thing for retail, blah, 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 blah. I'm not disagreeing with that, but it's coming full circle. And we talk about this all the time. At some point, the economy is going to come to a halt because of this. Now is it going to be all fire and brimstone? No. Is it going to be 2008? Well, it's anyone's guess, but it's coming. I mean, if you look at the balance sheets of these institutions, and we saw it with First National, we saw it with, what was the other one? I forget the other one.
Silicon Valley Bank.
Silicon Valley. Their balance sheets were all out of whack. They were out of whack because they had those, the bonds that matured, that lost all the interest. Well, it's going to be no different for all these different hedge funds that have sold all these stocks and have not yet purchased them. The reason they've not yet purchased them is because they know if they do, they're going to go bankrupt, because people aren't selling shares like they used to, because they've caught on. They know the game.
And maybe that's part of because we're looking for legislation, because Congress looks for ways to implement what we're asking for. So, and I'm not saying that this is the only one, but the Robinhood contract clause, for example, that clause that says Robinhood could basically decide if they don't want to, they don't have to honor your trade requests. Why should that be a legitimate provision? Why should that be permitted? If they have your money, they've accepted your losses, you might be on margin, they may have made interest on you. Why should they be able to? I mean, if there's a good reason, if you are on margin and you're past your margin, or you don't qualify otherwise, but there are probably things like that, like a contractual provision in a contract, that could be legislated. And our legislators could just pass a law. You can't have contract provisions that waive X, Y, and Z. And also there may be the regulation show that allows for the exemption. Certainly that could be tightened up.
Oh,
There should,
absolutely.
it should not be a broker exemption. If they want to provide an exemption, specify specifically what you mean, not some vague term.
Well,
Because
yeah,
if I'm a lawyer on the other side, I'm going to say, well, it says market maker. We think we're a
sure,
market maker. I mean,
sure.
it's vague.
Sure. And I don't know why, but this always pops in my head when I've thought about kind of all these financial rules and regulations and attorneys making all these different arguments. It makes me think and look, this is probably a bad analogy, but this is what it makes me think of is the Bush torture memo and how they justified waterboarding as, well, it's really not torture, it's enhanced interrogation tactics. And the reason I remember that so well is because I was in law school at that particular time, and we talked about that as being an issue. And it's almost as if the profession of law has become this more of a, well, we want to say yes. So how do we want to say yes to bad behavior? So we've got to bring the lawyers in to figure out how to say yes to bad behavior. And it makes you question, kind of the profession. And is that really what we should be doing? Saying yes to bad behavior. And look, everybody needs a good defense. Everybody's entitled to that in the Constitution, but this is getting out of hand, where we as lawyers in a profession can justify bad behavior. And the Iverson's a perfect example. How did it, as a lawyer, how do you make that argument that he's not statutorily unregistered when damn well he is? He pled guilty, though, and the judge even cited it. He's like, no, it says right here, the emphasis added in bold and italicized, he's guilty.
Yeah, maybe you would also think it might encourage FINRA, even though they probably couldn't say that was the reason. But you would think that once they found out that these guys were trying to register a sex offender, if he was so, that FINRA might think, wow, these scumbags who steal people's money are now trying to put out a sex offender in there. Maybe we should act. Maybe the SEC, maybe they should act. Maybe. I mean, how ridiculous. I mean, we're laughing, but it's so absurd.
It is.
It's disgusting, really.
It absolutely is.
It
makes you shake your head.
Yeah. So, and the rule is, again, the rule that would applied was to be disqualified, it had to be a felony, a particular felony. And so their argument was it wasn't a felony because he got a deferred entry of judgment. FINRA said you can call it whatever you want, but
here's what the law says, and it actually says deferred entry. You're convicted.
And I think the reason why I believe that Alpine didn't think their argument was a good argument because they didn't appeal, so that they got a ruling, and that was it. It dumped. And I looked up the gentleman, and he's elsewhere. He is elsewhere. But I think up and through 2022, so this guy from 2015 through 2022, with that history, is the who they wanted as the point man of Alpine. Anyway, we could
we can talk about this all night.
You saw Genius did a dividend offer. I think it was a dividend offering. And what I found interesting was they got the approval of the Singapore Supreme Court for that transaction.
Yep.
And what's interesting for me, maybe there's other locations that will be used for that purpose. And I was thinking of finger motion. That's another one of those naked shorted stocks. Finger motion is headquarters are in New York, but I think their principal place of business is Singapore. And where they do business is China. Right. But they're in Singapore, and maybe they will follow suit with something like that, because I know they assert that they have a imbalance in share count also. It'll be interesting to see if anybody else follows suit besides Genius. And I kind of lost track of Genius. That's Roger Hamilton. I kind of lost track of what he was doing. I know he had some issue. I think his lawyer told him to shut up. I don't know exactly, but I think in essence that's what kind of happened, or at least that's what I presume happened.
Well, he fell off the face of the earth because his lawyer told him to shut up.
Yeah.
I had been following that just because I had been listening to Roger Hamilton. He's a smart guy, but he kind of dropped off, and for good reason. His attorneys told him he needed to stay quiet. And I hadn't been following it, but I did see the announcement. I think the announcement came out before I went on vacation. I read over the announcement. It's going to be one of those things. It's going to be interesting to see. I mean, the share price is up. I think it's up like 70% since the announcement came out. So clearly, it had an impact. Now, whether or not that was covering of naked shorts, or if it was retail saying, "Hey, there's an opportunity here to make some money on the climb up," we'll see. Jeremy Palmer. Sorry, go ahead.
No, go ahead.
Now, I think he's spinning it out onto upstream. I'm not sure, but I think Jeremy Falmer with Vocal is attempting to do something similar. He's holding a space this week on Regulation CF, and I believe the spin out of the OG collection. So I'm going to listen in and see what he has to say. But yeah, it'll be interesting to see how Roger and Genius Group, how this kind of unfolds over the next couple of weeks.
Yeah, and the other thing was we saw, and we kind of talked about this early in the week, that Gorilla Technology, that company, I think it's based in England, how it basically took the West Christian path and came out very aggressively against naked shorts. Yeah. And we know, apparently it appears that Europe is a significant problem when it comes to these naked shorts. They either originate or end, a lot of these shares or these imaginary shares either originate or end up in Europe. And it was interesting that he came forward. I tried to get a hold of him. I'm going to try to get him on our live stream.
Wes?
No, the CEO of Gorilla Technology.
Oh, CEO of Gorilla.
Yeah, I reached out. It's a big time difference, but I reached out. We'll see if he'll come on. I was interested. I was glad he came out really aggressively.
It was a pretty aggressive PR statement. I mean, they all but said, "Look, we know what you're doing. We have evidence, and we're going to start pursuing things." Yeah,
that came out in the past week or so. The Gorilla Technologies. And it was, again, we liked it because it was super aggressive and they looked like they were on top of it. And so we were impressed. There were people talking about, I just want to briefly talk about that FINRA came out with their financial statement, and they ended up losing a significant amount of money. Most of it, I think, in trading. And the obvious issue is they have fines, but the fines are not commensurate with the violations or the size of the companies. And more importantly, I think, besides the fines, they don't assist in collection. So it's a royal pain in the butt. If whoever you got a judgment from doesn't pay, then you got to chase them down in court. It's a royal pain in the butt.
Which is absolutely ridiculous.
Yeah. And I think I saw some study that went out that it said at least 30%, if not more, were not collected of those, whatever those judgments. So on one hand, we talked about the good part of arbitration with that Robinhood case. On the other hand, this is the flip side. So last but not least, and I don't know if we're going to actually go and attend the trial. We might actually, maybe we'll be in the jury pool. But the week that JR was gone, there were a lot of things that happened about legal proceedings. One, Hunter Biden's he was trying to do a plea agreement. The judge didn't like the plea agreement for one reason or the other. Now, the judge in the AMC case didn't like the plea agreement either. I mean, didn't like the settlement agreement, but eventually signed off. So sometimes judges will say no the first time, but when you come back, if you correct certain deficiencies, then they might. I think they didn't. There were certain charges. I think there was 3 charges. there were a couple of tax misdemeanors, and then there was a gun charge. And I think the judge had a problem with the gun charge, the way it had been phrased. And so they rejected the plea deal. Once the plea deal was rejected, then they had to set it for trial, even though they can still enter into a plea deal. But once that happened, and since Biden's the president, they had a conflict. So the attorney general had to appoint a special counsel. That's why a special counsel was appointed. And that's why a trial date will be set. But my guess is they'll still try to probably work out a plea deal. There's a special prosecutor and special counsel. They're kind of used interchangeably. They basically have the same powers. The president used to only have the authority to appoint a special prosecutor. Now the attorney general can too. And what they do is basically they can investigate something, and if they think there's probable cause, then they can do a prosecution.
Yeah, as you and I, and we've talked privately about this, but there's nothing private about it. I tend to stay away from the political trials, even the Trump trial. I have not paid much attention to the Hunter Biden stuff, other than what friends have shared with me. I have a good friend that will send me stuff all the time. Just hey, looking at this, looking at that. It's just not something. I mean, I love the process and procedure. Don't get me wrong. I love kind of the strategy behind it, and I'm happy to talk about it. But I just tend to shy away from, those types of trials, because you truly never do know if they're witch hunts or not. I mean,
where are the blue sheets, by the way?
I'm not defending Hunter Biden. I'm not defending Trump. I just, you get those types of hot button issues just tend to get my blood boiling. So
but I want to know why you, JR, why are you defending Hunter Biden? I understand why you're defending him. No. Just to be clear, I think the trials themselves procedurally are going to be interesting.
Yes,
so
they will.
So we'll deal with them on a procedural basis. We're not gonna substantively say, we want one side to win or the other, or deal with it in that basis. But I thought it was interesting procedurally how they got to the special counsel and what's going to probably happen. And I'm sure it wasn't a very happy day when the plea agreement was turned down. I'm sure that caused a lot of butterflies for somebody. But anyway, if it goes forward as a trial, then we'll address the procedure of the trial. If it gets resolved on a plea, then we'll just address it as such. The other thing, I'm sorry, go ahead.
No, I was just going to say, the thing that always amazes me, that interests me about the Bidens, and look, I don't know the Bidens, but I worked, when I was in law school, I clerked down in the Delaware Department of Justice, and I worked with two guys that went to school with Biden's kids. And in a small state like that, everybody knows everybody. And I was blown away by how many people would say, I met Joe Biden here. Yeah, I talked to Joe Biden there. Yeah, I met his kids and have met Jill and blah, 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 blah. So that always amazes me. But as far as, what the Bidens have done, what they do, what they don't do, I just never took an interest in that. But I also never took an interest in what Trump's children did or didn't do, or any of that. So the process and procedure is where my interests fall.
And we talked about this because, again, we don't want to deal with the kind of all the drama, let's just say. So the process we could talk about without drama, and we could still be informative, I think. So that's interesting. And the same thing I was going to say, and JR was not around, but during the week, SBF, his bail got revoked, and he got sent to jail.
Yeah, I did see a picture of him in prison. That was the extent of knowledge.
And the reason why I'm saying this is going to be interesting, but he was accused of having leaked some information to New York Times for them to basically, I think, write negative stories about the central witness. And he's accused of intimidating witnesses. In essence, that's kind of what the accusation was. And the judge, I think, read him the riot act beforehand, because, in any civil case that I've been in, when there's a jury, the courts are really careful. They're really careful about what the jurors hear, what they say, about what you say. You're warned as an attorney. I had one case in a small town. We had an order against talking about something. My client, who knew that he couldn't talk about something, and it wasn't like it was insurance. That was the issue.
Why don't you talk about the difference between a gag order and a non-disclosure agreement for the group?
Well, this is not even a gag order. It's like because I don't even think the order was a gag order. It just said, so there's two things. As the SBF, it was a matter of intimidating and influence witnesses. Right. So former President Trump, he's got several legal matters going on, and recently in one of those, he had been warned before, but the judge gave him a further restriction on basically discussing it with witnesses and being too flamboyant or public about his position and influencing witnesses. And so the difference was SBF went to jail and the judge warned the former president. Could he order him, what's the remedy? So if the judge says, don't say it, and you say it, what's the remedy? They could send you to jail. So that's what they did with the SBF. With the former president, I doubt if anybody is going to be sending him to jail. But if he was really publicly blatant, then maybe. I had an occasion once where I had a client, the judge got pissed off at him without notice on a weekend. He gave him literally an hour to go get a cashier's check to pay a sanction to the court, or else he was going to go to county jail for the entire weekend. And when I mean county jail, that's LA County Jail. LA County Jail. That is not a place you want to be for a minute, let alone a weekend. And that was a judge getting pissed. When my client said something that he was told not to say, the judge stopped the trial at a convenient spot. He called the attorneys back into chambers and he ripped me a new one. He asked me if I was involved, whatever. He was pissed and he talked about a mistrial. So the fact that they are trying to put the kibosh on the defendants not to speak is not unusual. It just happens to be these are unusual defendants, and we usually don't see it. But I can understand from their perspective, they're used to talking and influencing people, and it probably is a very unusual experience. Yeah, LA County Jail by far. I visited somebody once there, and that by far the scariest place I have ever been in my life. And I've been to Alcatraz. I've been in a cell in Alcatraz, not because I was a convict.
Well, I was in a cell in Alcatraz too.
Yeah,
but.
Right. I also went to like some prison. I've been to Chino, which is a prison. I've been to another federal prison in middle of California where, they open your trunk as you go in, not when you go out. They check your trunk as you're going in, and they make you remove your shoes and belt. Some of these guys, when I went to county to visit somebody, guy would walk in and you'd get this chill that would come across you. And these were the guys that had these tattoos on their eyelids, like a swastika tattoo on their eyelids. These were some bad dudes. So my judge was willing to send the defendant to county just because he was late. So judges do a lot of, have a lot of authority, can do things. And, if the judge sends you to county for a weekend, by the time you have a chance to appeal that, you're out. You're out. That's it. You're hopefully you're still with it, but you're done. So anyway, as to those trials, we'll discuss them procedurally. We're not going to discuss who we like and whatever, but the fact that they were both warned and both are kind of have limitations is not unusual. And a gag order would be you couldn't speak at all. Like right. And the judge didn't give him a gag order, gave him like be prudent order. A non-disclosure agreement or a confidentiality agreement means you just can't disclose what the topic is, but a court or a judge can order you to disclose no matter what. So I've had plenty of non-disclosure confidentiality agreements. You could take them before a court and the judge could order you to disclose it. Isn't that exciting? Was it Jack? I don't know. Jack in the Box. I think it was like Jack from Jack in the Box. It was, as it turns out. I wanted to talk to you about robots, but let's do that next week. Because we've gone an hour and a half. That's about as long as I can.
We're about 30 minutes over.
Yeah, that's about as long as you could tolerate me. So, so to everybody out there who followed this, like, subscribe. Thank you for following. Hopefully there's something that helped you. And if you have questions, by the way, so this will be available on on YouTube. If you have questions, you can put the questions, any specific questions, in the YouTube feed, and we'll see them and we'll respond. And if you think, and we'll put up a poll, if you think there should be a gag order on JR, let me know.
I'm sure I've got a couple of friends that wouldn't mind me gagged. So I had a friend watching tonight. They were texting me during this, so I'm glad they enjoyed it. So always lots of fun, Richard. 6:30 Sunday nights are, it's fun.
Yeah, it's fun.
Yeah, so
always a lot to talk about.
Yep, absolutely.
Yeah. So we'll see you next week. Everybody
all right, man. Talk to you soon.
Have a great week. We appreciate you being here and appreciate all your comments. And take care, everybody. Be well. And hopefully there'll be some news on MMTLP and other things this week. Because obviously we're allude to that. And obviously when my stuff is filed, I'll put out a video saying it's filed. Everybody have a great week.
All right, brother.
Take care. Take care.
Yep. Later.